Hello. Good morning. Good morning, my friends, and happy Monday. Today's Monday, September 23rd, 2024. Do you know where your children are? Hope everybody had a great weekend and was able to decompress after the Carly Gregg verdict. So many of you have asked me to cover the Ashley Benefield hearing that we're going to do it today. We're going to do it today. This is a hearing that happened actually on September 16th, and I had scheduled to do it live, except nobody was broadcasting it live. So we did not get to talk about it or review it or go over it, but we're going to do that today. We did go over the initial motion papers, and I have linked that stream below for anybody who didn't see them, or that stream, which was a while ago. And our friend Jules was in the courtroom, our court watcher, Jules in Florida, for this hearing on Ashley Benefield. And she's going to come on after we go over the hearing and talk to us about what she observed in court and some other things that happened that are not discussed during this hearing, and maybe some conversations she had with some of the players involved here. So stick around for that. And for Sarah in shock and horror, gifting 10 memberships right out the gate. Sarah is a new mod. Welcome to the Mod Squad, Sarah. We are so happy to have you. And that was really super generous. And for those of you who are gifted those memberships randomly by YouTube, congratulations and welcome. I think you're going to like it here. Thanks, Sarah. And Naomi Parker became a member. Welcome, Naomi. I also have a really great show scheduled for 1 p.m. Eastern today. Bridget Todd, Carly Gregg's attorney, is going to be joining me to answer all of my questions and all of your questions and to give us some more insight into Carly. And I spoke to her on the phone for about an hour. She's amazing. She is like wicked smart, wicked smart. She's compassionate. She's kind. She has so much to say, and I can't wait for you to watch that with me. So if you're interested in that, make sure you hit the notification. When this stream is over, I'm going to teleport you over to that one so you don't have to worry. You'll get there and you can hit your notification bell for 1 p.m. Eastern. And she's got so much to tell us, so much stuff that was not allowed at trial, so many of the burning questions that I have been asking myself throughout this trial through you, and that you have been asking, and it's going to be a really good show. Thank you, Yuri's math teacher, for coming in and gifting 10 memberships. And Yuri's math teacher is always such an amazing part of this channel. And to those extra 10 people, so now there's 20 gifted memberships, and we're not even like 4 minutes in this morning. Congratulations and welcome. YouTube is glitchy for me today. I don't know why. When I go on the chat, like I cannot even sort it into all messages. It just says top messages. I've had this problem for like days, and I don't know what it is. Thank you, Yuri's math teacher. And thanks, Mozzie, who's been here for 6 months and loves being a cupcake. Thank you so much. I did watch the Shanna Gardner hearing this morning. I didn't know if it was going to be broadcast live or not. And you didn't miss anything. You didn't miss anything because it was basically a scheduling hearing. That was it. They're scheduling depositions. They're scheduling dates, trying to get a judge is kind of trying to figure out when the trial is going to be. And they're talking about end of next year. So there's nothing super exciting to report to you on that. So I'm kind of glad that we didn't go live on that because it was really a big nothing. Hi, Wolfie Muse, and thanks for becoming a member. But I thought you already were a member. Maybe you re-upped. Anyway, welcome. Yeah, this is going to be good today. Oh, Kurt is here. Kurt, please do not stir up trouble in my chat today because it's not, just, please. I'm asking really nicely. Thank you. I know we have differing opinions on this case, and so I just really don't want to, it's Monday. It's Monday. All righty, let's go to Manatee County, Florida. This hearing was actually held on the 16th of September. And we are going to see Neil Taylor in court arguing those motion papers that we already went over. StreamYard has this like new thing. Check this out. This is kind of weird. I can make my camera a circle now, or I can make my camera a square now, or I can make, oh, and look at this. We can even round the corners. I, it's a little bit odd, but okay. I think that StreamYard sold to a different company. So there's like all these kind of weird new features, but who knows? Maybe we'll come to love them. Who knows? You never know. Sometimes the things you hate in the beginning, you wind up really loving. That goes for people too. Sometimes you have a bad first impression of a person and then they wind up being one of your best friends. How often does that happen? It happens. Then we can debrief a little bit about the 2020 episode on Ashley Benefield if you guys watched that. Honestly, I don't know if I ever finished it. I kind of got like bored by the second half. I think I did go back and watch it. It seems like a year ago now already, right? All right, I have sped this up because, as you may recall, Neil Taylor is a slow talker. So even when he's sped up, it's kind of sounds like he's on regular time. Oh, let's see. When sharing documents, you like the circle? Let's see. Let's see what it looks like. Feels like I'm so small. Hmm. Okay, he's sped up a little bit. I've turned on the closed captions. I think the audio is pretty good on this, so I don't think we're going to have any issues with the audio. So this is the motion for a new trial based on juror misconduct, and this has to do, you may recall, with juror number 15 and a user by the name of That Hoodie Guy, who was apparently in the law and crime stream during verdict watch and was saying or claiming that his sister was on the jury, that she snuck a flip phone into the jury room and was texting him and was giving him all kinds of deets about what was going on in the jury room. I don't think that's the strongest part of the argument. I think the strongest part of the argument is the argument about juror 15, whom defense attorney is arguing lied on her jury questionnaire when she was asked about whether she had been a perpetrator of DV or a victim of DV. And as you recall, when we went over the papers, he has receipts on that. So let's see if this argument, no spoilers, please. I know some of you have watched it. There is always a hoodie guy. There's always a hoodie guy. And it's funny because the other day, I think, listen, when the chat is moving so quickly, Will, that sometimes, mods are modding on their phone and they'll time out the wrong person because, it's a very small chat on your phone or somebody gets blocked. So somebody got blocked by accident. And I went back to check because, the blocked list. There's no way to sort it even by date the person was blocked or alphabetically or search for a blocked person. So you have to go through like hundreds of names. And that hoodie guy had already been blocked on my channel. So we were wondering, Team Brittany said, I wonder if that hoodie guy, wouldn't it be so funny if he showed up today in your chat? And I'm like, yeah, no, you guys took care of him a long time ago. So who knows what he did here to deserve that one-way ticket to Block Island. But we got him early on. All right, here we go. Neil Taylor in court, Manatee County, September 16th, motion to grant a new trial based on juror misconduct and or juror interviews. Somebody asked about the Boulder case. The Boulder case, they are in jury deliberations. I have not had a chance to go back to that. I was going to come back and watch closing arguments with you. The problem is the feed is so terrible. It's a WebEx feed and you can't see anything. It would be more of just an audio podcast. There was some interesting testimony by Ahmad's mom testified. She wasn't shown on camera, but it was really interesting, even though there was an interpreter, and sometimes that just takes longer to interpret the questions. The family knew about these crazy things that were going on with him. It's heartbreaking. I hope to cover the verdict, and maybe depending on how long it takes, we can catch up and do closing statements. It's based on demand, so it depends on what you guys want. If you guys want to do closing statements on the Boulder trial and for me to just recap all the testimony up to that, we can. I know that closing arguments were, I think, 90 minutes for each side, and then there was a rebuttal by the state. I think the jury is going to be out a long time because, yes, JD, I know you were into that case. You're an audio professional? Oh, help. It took trickery to make it easy to hear. It was really interesting to watch. Yeah, it was garbled though. I found the audio when I went back to listen to the closings. The audio was kind of garbled, so it's hard. But whatever you guys want, we'll go back and do it. And I think the jury is going to be out for a long time on that. What do you think, JD? I mean, the verdict slips alone are voluminous. So you just let me. No, it's not that it's not good enough settings for public consumptions. I've been covering this because I have strong ties to Boulder, Groovy Cheryl. I went to college there. I'm a buff. And I love Boulder so much. I stayed there to go to law school and went to the University of Denver Law and lived in Boulder at the time. And that was my King Super. So I have a really personal connection to that case. It's just that I just want to give you guys the best quality stream. So I didn't cover it like live. But you let me know. You let me know. Closure. Yeah, we definitely need some closure. And it's a very personal case for me. Christina, Jules is going to come on and give us her thoughts on how Ashley is doing. So let's go. Let's get into this hearing because it's about hour 15. So here it's on 1.25. If it's too fast for you, let me know.
Is this just the voir dire?
It's the entire first day.
First day. All right, thank you.
All right, Your Honor, on behalf of Ms. Benefield, and pursuant to our motion to interview the jurors, which a lot of which was incorporated in our motion for new trial, first thing I want to address is the juror misconduct. The court has pretty much framed the parameters and that the prosecutorial misconduct allegations are for another day, if at all. So for today, we're going to discuss what I've characterized as identifiable and unidentifiable juror misconduct.
So it sounds like he may drop because he said, if at all, the prosecutorial misconduct motion. So that's interesting. Maybe he's saying depending on what happens with the outcome of this motion.
I think as it relates to identifiable juror misconduct, that term is being used and focused exclusively on juror number 15. That was Sarah Walcott. And I want to remind the court as I go through my argument that at the conclusion of jury selection, the defense still retained one peremptory challenge. Now, the most compelling evidence of identifiable juror misconduct as it relates to Ms. Walcott is the following. First thing I'd like to do, Your Honor, is supplement to our Exhibit E on our motion for new trial or Exhibit B on a motion to interview jurors. I want to supplement it with a copy of Ms. Walcott's questionnaire. If I could have the court mark it. Does the court want a separate copy?
Yes, please.
Yes, I have copies for everybody.
And clarify again, you said this is an additional page to Exhibit B of the defendant's motion to interview jurors.
Yes, B for the motion to interview jurors and E for the motion for new trial. And may I present a copy to the clerk for marking?
Yes.
So
I agree, Rosie. Rosie says, why are they exposing her name? That's outrageous. I agree, Rosie. But unfortunately now it's part of the court record. She actually made an appearance in this case. So yeah, not crazy about it either.
the questionnaire, Your Honor, contains a very obvious admonition that says, under penalties of perjury, I declare that I have read the foregoing jury questionnaire and swear or affirm that the facts stated in it are true. Now, one of those questions, as I've highlighted for the court and for the record, is, quote, have you or a member of your immediate family been, unquote, victim of a crime? Ms. Walcott put an N in that block indicating no. We filed in our motion for new trial under Exhibit E and in our motion to interview jurors, Judge White, under Exhibit D, a domestic violence injunction petition filed by Sarah Walcott in case number 2016 DR 001301AX. The facts also include are that her then boyfriend, Albert Ballinger, was arrested on February 20th, 2016 for allegedly grabbing her hair by the back of her head and slapping her across the face 5 times. The deputies observed redness on the left side of Ms. Walcott's face. Mr. Ballinger was arrested, and Ms. Walcott filed a petition declaring herself to be a victim of that offense. That is in absolute and direct contradiction to the form that she signed under oath. Additionally, Your Honor, during the voir dire portion of the trial, the following questions were asked. There's not a whole lot of relevant ones, but to set the stage for the court before I read the exact questions, Ms. O'Donnell had asked about child custody matters, and I had asked about experience in the domestic violence courts. Here are the specific questions that were asked and the pages and lines where they appear. On page 233, Judge White, line 9, Ms. O'Donnell asks, have any of you here ever had any dispute with your significant other about your child or the custody of your child? Additionally,
If you have earbuds in and you listen very closely, you can hear the defense attorneys whispering to each other. Sometimes you can make out what they're saying to each other. Hot mics.
Ms. O'Donnell asks on page 234, line 23, has anyone here ever had like a heated custody battle with anyone? She then acknowledges another juror, 26, who raised their hand, and she goes throughout her voir dire very meticulously back and forth, each side of the courtroom, left and right. As the court knows, the jurors were numbered to a certain amount on the left side and then the remainder on the right side. Additionally, on page 236, line 17, Ms. O'Donnell is heard to say, and how about over here?
I'm sorry, you said 276?
236.
236.
Line 17.
Thank you.
If I'm going too fast, Judge, let me know. I'm sorry.
I'm just writing as fast as I can. Go ahead, sir.
You are not going too fast, Mr. Taylor. I have you on 1.5 speed right now.
On line 17, Ms. O'Donnell asks,
Oh, sorry.
and how about
Sorry. It's the state attorneys. Didn't I say that? The state, I'm sorry, the prosecutors. The prosecutors. Mr. Taylor is the defense attorney.
over here, indicating to the right side of the courtroom where Ms. Walcott is seated? There were several other people that raised their hand. Anyone that's had a contentious battle besides number 26 in the back over here? How about over here on this side, number 51? On the next page, 237, Judge White, line 15, Ms. O'Donnell asks once again, and who else over here on this side? And she calls out juror number 62. On page 38, and this is still over child custody matters, page 238 on line 14, Ms. O'Donnell asks, okay, someone else raised their paddle. 38, and you had a custody dispute with your children? Prospective juror, 38, yes. And finally, on page 239, Ms. O'Donnell goes back to the other side once again. And on line 8, she asks, anyone else on this side of the room? Okay, no one else. Now, she finishes her voir dire and the court calls on me. And on page 283, Your Honor, line 19,
Yes, sir.
I asked the following question of the veneer. Has anybody in the prospective veneer been involved in domestic violence courts? There's a show of paddles. I follow that up by asking on page 284, line 8, how many of you know or have experienced an abusive male? And I might add that the court reporter, of course, is diligently noting the paddle numbers of the jurors that respond affirmatively, and the court will note juror 15 is not among them at any point. And the court reporter even goes so far as to say on line 22 of the same page, 284, court reporter, wait a second, I need your paddles. Don't just yell out. Now let's look at what.
Okay, so I asked for no spoilers, and then I just saw somebody put a spoiler. Yana, stop. Okay, thank you.
The evidence is that we produced for the court in light of those voir dire inquiries. Well, first, we provided, Your Honor, with Exhibit G to the motion in new trial, or alternatively, Judge White, Exhibit E for the motion to interview jurors. We provided the court with a domestic violence injunction where Sarah Walcott was the respondent, the person that it was filed against. It was by her ex-husband. The case number is 2003 DR 4890. This was a domestic violence injunction filed and sought by her ex-husband, Charles Walcott, on behalf of their minor son, Hayden Walcott. The ex-husband sought custody of the minor son. The petition was ultimately dismissed, but for our purposes, that's completely irrelevant as it was filed against Ms. Walcott. In case that's not enough, Your Honor, as Exhibit H to our motion to new trial, which was Exhibit F to our motion to interview jurors, we attached another domestic violence petition filed against Sarah Walcott, case number 2004, DR 002205. It was an injunction once again sought by her ex-husband, Charles Walcott, once again on behalf of their minor child, Hayden. In this instance, the court issued a temporary injunction to Mr. Walcott, and Mr. Walcott sought and was granted temporary custody of the minor child, Hayden Walcott.
When he says injunction in Florida, that means restraining order.
Mr. Walcott's accusations in that petition alleged child abuse against Sarah Walcott, and specifically stated that Sarah Walcott, quote, picked up the minor, Hayden, by the arms and slammed him against the wall. The significance of that, of course, Judge White, is that Ashley Benefield made child abuse allegations against Douglas Benefield. And I assure you, especially given the voir dire that the court conducted, we took several hours that the court patiently went through all prospective jurors that were subject to cause challenges. I have a very high degree of confidence had this information been revealed, Ms. Walcott would have gone out on a cause challenge, and I don't think that the state would have objected to it. However, that too is really irrelevant because the defense had a peremptory challenge that remained, and I can tell you unequivocally we would have excused Ms. Walcott had it been disclosed. Additionally, Your Honor, Hayden Walcott, again, this goes to the voir dire question about how any of you been involved in the domestic violence courts. And the court may recall that the petition, the questionnaire rather, that Ms. Walcott executed says her or her immediate family, which would include her child, Hayden Walcott. We attached as Exhibit F to our motion for new trial, which is also Exhibit C, as in cat, to our motion to interview jurors, an aggravated battery charge against a pregnant victim, case number 2014 CF 3121, against Hayden Walcott. She was the victim.
Okay, if you are not picking up what he's laying down, we went over this when we went over the motion papers, and this is heartbreaking. But the child of the juror 15, who they had been fighting over custody about many years ago when the wife, juror 15, had been accused of DV against her husband at the time, that little boy grew up and then was allegedly abusing his pregnant girlfriend. This is what we mean when we talk about the cycle of abuse and generational abuse. When you grow up in a situation where you think that this kind of behavior is normal, this is oftentimes what happens. Children who watch or have to see or live in homes where there is DV grow up to sometimes either be perpetrators or be attracted to that kind of person because that's their normal. Ashley Boyer, no spoilers. Thanks for covering this. I didn't know they streamed it. Thanks, Ashley, for your 5.
Victim, Mr. Hayden Walcott's live-in girlfriend. He appeared on the scene heavily intoxicated, and Sarah Walcott posted the cash bond for him to be released. Once again, despite the question about domestic violence, no disclosure. And finally, Your Honor, again, as it relates to the voir dire, in a bar fight charged with felony battery on June 1st, 2024, this would have been right prior to us selecting the jury and the trial commencing, in Manatee County Sheriff's Office arrest number 2024-012314, which I would also at this time ask that the clerk mark as a supplement to.
Wait, hold on. Who was in a bar fight? The son? Wait a second.
Intoxicated, and Sarah Walcott posted the cash bond for him to be released. Once again, despite the question about domestic violence, no disclosure. And finally, Your Honor, again, as it relates to the voir dire, in a bar fight charged with felony battery on June 1st, 2024. This would have been right prior to us selecting the jury and the trial commencing. In Manatee County Sheriff's Office arrest number 2024-012314, which I would also at this time ask that the clerk mark as a supplement to our exhibit F to our motion for new trial and mark it as F2.
Any objection? State.
Relevance, first of all, I don't know what it is. First time I've seen it.
It's the arrest affidavit of Hayden Walcott for what I just stated.
I don't know how that's relevant.
Oh, so it is the son of juror 15 who, before jury selection, right before jury selection, was arrested for felony battery in a bar fight.
All right, so there's no objection is relevance. Any other objections? Go ahead. Overruled. So mark that as
to exhibit F of our motion.
F2. F2. All right. Yes, sir.
This is a bar fight on June 1st, 24, where Mr. Hayden Walcott is observed on video, according to the deputy, punching the victim in the face with, quote, significant force, once again, not disclosed in voir dire of the questioning of Ms. Walcott about abusive males or domestic violence. The second part of our presentation, Judge White, goes to the unidentifiable juror misconduct. And that is where we have a witness standing by to testify. I'll go through it if the court likes, and then I would like to call the witness, but of course that'll be up to Your Honor.
He's got a witness ready to testify.
So this is what happened. If the court recalls, on the evening of the verdict, the first thing that occurred was a question from the jurors about whether or not Dr. Quintel's conclusions about Doug Benefield being A, super controlling, B, a real alpha male, and 3, having an issue with intimidation, was Dr. Quintel's conclusion or based upon information that Ashley provided to him. At the time they asked the question, I took the position, believing it to be pretty simple, that a readback of Dr. Quintel's testimony would quickly put an end to that consideration, because my question to him was, did you, Dr. Quintel, as an expert trauma specialist, reach any conclusions as it related to Douglas Benefield? There was a dispute with the court about whether or not the jury knew that they could ask for a readback, but what then followed, Your Honor, was a really puzzling and very alarming recitation of events on a public website by law and crime networks called Verdict Watch. We were able to capture it.
Remember, the jurors had questions about Dr. Quintel's testimony, Quintal, and because they didn't say the magic words, can we have a read back? The judge denied it. This is Florida. You need the magic words to get the read back. Massachusetts, you can't get a read back.
Before it was taken down, and it was taken down pretty soon after it was posted. But there was an individual by the name of that Hoodie guy. And what was so alarming about this was that everything that the Hoodie guy reported came to pass exactly as he reported it, but a couple of minutes later by the jury. So, for example, at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, the Hoodie guy posted a comment stating, "Verdict incoming." That's Exhibit A1 to our motion for new trial.
All right. I'm looking directly at that. I'm looking at motion to interview jurors. I'm looking at defense exhibit A1, the first page of that.
On the motion for new trial. I'm going back and forth between the motion for new trial and the request to interview.
All right. Then is the exhibit in the motion for new trial different than the motion to interview jurors? Because I'm looking at A1 from the motion to interview jurors. It says exactly what you just said.
I believe we repeated it. Let me just do a real quick check here. Yes. These are the actual screenshots in the motion to interview jurors that we provided for the court. The summation that I'm giving the court is coming from page 23 of our motion for new trial.
Okay. So my question is, both on page 23 of 26 of the motion for new trial, and today during your oral argument, you've referenced verdict incoming as being at 10:20 p.m. The what I've been provided doesn't have a timestamp. How are you able to make that assertion?
I believe we made that assertion by virtue of preserving and noting as it was taking place what was happening. And that's one of the reasons why we have the witness standing by, Your Honor.
Okay.
All right. So the second thing that happens, that at 10:25 p.m., moments before the jury comes in, that Hoodie guy posted a comment stating, quote, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. Now, the court may recall that following that first question and the dispute about the readback, the court told them rely on your recollection and sent them back out. They returned shortly thereafter and said that they were home. This was what was posted as a result. The next thing that's posted at 10:27 p.m., according to that Hoodie guy, is a comment stating, my sister snuck a flip phone in. That's Exhibit A3.
For those of you who are confused about who that Hoodie guy is, so that Hoodie guy is just a YouTube name. I don't think this guy or whoever is, or maybe a girl, for all we know. That Hoodie guy, that's just their handle on YouTube. Like everyone has a name here, right? And that Hoodie guy was in the law and crime chat during verdict watch of Ashley Benefield. And these are the things that he was posting in the chat. So Mr. Taylor, the defense attorney, has screenshots of this, and he's got a witness who's willing to testify about these screenshots that happened in the law and crime chat. He also said that it was taken down quickly thereafter. But that Hoodie guy said that his sister was in the jury room and she snuck in a flip phone and she was sending him these messages, and everything that he apparently said in the chat came true.
At 10:28, Your Honor, that Hoodie guy posted a comment stating, I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. Exhibit A4. At 10:28, that Hoodie guy posted a comment stating, my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter. And at 10:30 p.m., the jury comes in and announces they have a verdict of manslaughter. And that was a mere 2 minutes after the Hoodie guy posted what he did. I will defer to Mr. Pinnell and any discussion the court wishes to have with him about juror interviews and what the rule says. But I would remind the court that the standard in the rule is not very high. It requires reasonable basis to believe that the verdict may be subject to attack. And if so, if that is shown, the court does not have discretion according to the rule. The rule says the court shall order an interview. And of course, that's the whole purpose of the interview. It would be to discuss whether or not something like this, in fact, took place. I further tell the court that as it relates to Sarah Walcott's falsification of the questionnaire and refusal to disclose on Voir the independent evidence that we've discussed here today, I do not see respectfully any way that the court's going to be able to get around that. That is misconduct proven beyond any doubt. And you can try to parse the question, have you been involved in the domestic violence courts any way you like? But I don't think you'll be able to do it in such a manner as to eliminate the fact that you had not one, but 2 domestic violence petitions filed against you, which you did not disclose, and that your husband sought custody of your minor child, and you did not disclose that either in response to the state attorney's question. With the court's permission, I'd like to call Ashley Boyer now to testify to the...
Judge, I'm going to object. I have not been notified of any witness. They have not listed any witness. I have no idea who this witness is. Their discovery obligations are to tell me who their witnesses are, so I have the opportunity to know who they are before they call them. So I don't even know who this person is.
This is a person who approached us after the verdict or immediately before the verdict to show us pictures of what was being posted on the Law and Crime Network's Verdict Watch, and told us that she thought initially that it was just some troll that was looking to inject themselves into the proceedings. But when she noticed the timing and the subsequent verification, if you will, by the jury's actions, she brought it to our attention because she was concerned. She is independent. She's not affiliated with the defense in any way.
Has she been disclosed?
We haven't had a discovery request for this hearing, Your Honor.
So, the state has to ask for that information?
No, we haven't. We never received it.
So has there been a disclosure pursuant to the rules? You have to list, well, you know what?
Yeah.
All right, so no.
In addition, we did not know if the court was going to actually take testimony here today.
So don't disclose her unless I decide to list hear her and then disclose her.
So,
Oh, Judge Matt White is not having any of it. Melissa Crawford saw those comments from that Hoodie guy in the chat in Law and Crime that night, but you were not the witness, right? Right, Melissa Crawford. But I think a lot of people heard them. A lot of people screenshotted them. There are receipts. I don't know how many subscribers he has. That's not really the point. He's not a YouTuber. He's just someone who was participating in the chat. And the point is that if you're on a jury, you're not allowed to bring your phone in, and you're certainly not allowed to be communicating with people outside the jury room about what's going on inside the jury room. So that is the real issue. That's the problem. That is juror misconduct, as is lying on a jury questionnaire. So he's not going to let this witness testify, but let's see what else happens. And let's see what Ms. O'Donnell's argument is.
And you want her to present testimony remotely.
Yes, she's,
Have you filed a motion under Rule 3.116?
she's about 9 months pregnant.
Okay, all right, then I mean, the rules are clear. Now, I'm confused. Was that the opening, and then you're going to do the closing?
No, I was just going to discuss. I was going to discuss the rule and the case law.
All right.
That's our motion.
Just,
Do you have anything else you want to say, and then I'm going to go to the state?
Yeah, I have one other request for the court. We're under the impression, Your Honor, that there is court security footage, video that's maintained. If there is, we'd like to make a request that it be preserved, because we think it may show Ms. Walcott and whether or not she responded in any capacity. Trying to give the court reporter the benefit of the doubt that maybe she missed Ms. Walcott holding up a paddle to any of these things. So to the extent there is such footage, in the interest of justice, we would like Your Honor to take steps to preserve it.
That's an interesting request, because he's actually showing Ms. O'Donnell some grace. And he's saying, look, Your Honor, if there's video of the voir dire when they were asked to hold up their hand or their paddle, saying, when Ms. O'Donnell was asking the jury panel, have any of you ever been in a dispute over custody? And then he said, people raised their hands. He's like, in the interest of I don't want to sandbag Ms. O'Donnell or anything. So if there's video of that, I'm just going to ask that you preserve it. He's not even saying, let me see it. He's just saying, please preserve it, just in case juror 15 did raise her hand. And by some miracle, the prosecution did not see it or did not ask her that question in follow-up. So he's technically not calling juror 15 a liar, saying she may have raised her hand, but we need to know that, because if she did, we certainly would have questioned her more, and we certainly would have not wanted her on the jury. Susan Costello, thank you so much for the very generous $50 super sticker, and to all of you who are watching with me today, because without you guys, this channel is not what it is. You have compassion, you have empathy, you have understanding, and you're just some of the kindest people that I've ever known. And I see how you support each other in the chat, in real life, and also in the comments. So thank you so very much.
Mr. Pinnell will address with the court any questions of law that the court has.
All right, I am not the custodian of the information that you're referencing.
I understand, but I think if the court asks that it be preserved, I have a high degree of confidence that it will be. Is that acceptable to Your Honor?
Sir, I'm not the custodian. If you want to file a motion, I guess we can have the parties here and we can be heard on it, but I'm not the custodian of those records. State.
first, Judge, I would object to the lawyers tag teaming with their arguments. This is one lawyer can do these arguments, whether it's factual or legal. That being said.
Okay. Okay. Kind of like the way you sort of tag teamed your your closing with your sister attorney. Where was that they said my brother, my sister? Oh, it was in Massachusetts. It was during one of the Karen Reed hearings, where all of a sudden one attorney started saying, my brother, my sister. That's the way they address attorneys in Massachusetts. We saw that, I think, during one hearing. We never saw it again. So you did tag team on your closings. One of you did it first. The second one did a rebuttal, but it wasn't even really like a rebuttal. It was like a whole second closing where you started bringing up all kinds of stuff that wasn't even in evidence. So I don't know. You may want to take a step back on that argument. The other attorney that he's speaking of is the law guy. He's the law guy. It's what attorneys do when they're doing trial practice and heavy motions. There are people whose skills are trial lawyering and trying cases. And there are other attorneys who excel at appellate work, brief writing, and the law and drafting motions. So it's perfectly acceptable. She doesn't like it because she feels like, I guess, she's being double teamed, but come on.
I first want to address the paddle issue. The representation that Mr. Taylor has made about what happened in jury selection with those paddles is completely and 100% inaccurate. When those questions are asked, paddles are raised. The court reporter does not write down the number of every paddle that was raised. Not once have I ever seen in a transcript that the court reporter tries to write down 30 different paddle numbers as to who raised their paddles.
He's asking for a video of the proceedings, not a transcript, but okay.
I cited in my motion 2 different places where I asked very specific questions, and I started asking questions in response to that. I can represent to the court that I almost never go to every single person that raises their paddle. That is a habit of mine. I don't go to every person that raises their paddle. So to make the assumption that someone did not raise their paddle based on the fact that I did not speak to them, I think is completely improper. And I also believe that the defense asking the question, has anyone had any contact with domestic violence courts? He says in his response 2, which I'm assuming means he saw 2 people raise their paddles. Nowhere in that transcript does anyone say what numbers raised their paddles. It is quite possible that Ms. Walcott did raise her paddle, and we are sitting here maligning her, acting like she withheld this information inappropriately, which I find highly objectionable. And the rules for this sort of thing, interviewing jurors, yes.
What I find highly objectionable is that he's coming in with receipts of proceedings that this juror was clearly not only a perpetrator of DV and also involved in a contentious custody battle, she was also a victim of DV, and she also was involved with her son's case, who was also allegedly a perpetrator of DV, and she can't say she didn't know about that case because she posted his bond. So, okay.
Jurors can be interviewed, but what Mr. Taylor did not mention is how strict the standard is in order to get to the point where you interview a juror because of public policy reasons. Because how are we ever going to get jurors to come in here if they know that after the fact, someone is going to dig into every aspect of their life and call them liars when they didn't lie and distort the record to meet their own needs? There has to be a line drawn.
Oh, but if it's accurate, she did lie. See, that's the thing. Do you want to get to the truth, Madam Prosecutor, or do you just want a conviction? Because you got your conviction. Do you want to get to the truth? Is it okay for jurors to lie on their questionnaires and never get called out on it?
Drawn. And I would like to bring the court's attention to, it's in my motion, but I'll state it just briefly. The case of Baptist Hospital, which is cited in my motion, and also the case of State versus Hamilton, which I believe defense also just provided. It says, when you're talking about juror non-disclosure, however, in the light of strong public policy considerations, Florida law only allows juror interviews in limited circumstances where the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and so prejudicial as to vitiate the entire proceeding. And additionally, in Hamilton, it says
it's vitiate, but I'm not gonna snark over your pronunciation. Tell me what you think. If you're the defendant, Ashley Benefield, or you are her attorney, and you find out that a person who's on the panel has been, as I just laid out for you, a victim, a perpetrator, would you want that person on your jury? Especially the perpetrator side, would you want that person on your jury? Do you think that absolutely could vitiate the proceedings? Do you think the result might have been different if this person wasn't sitting on the actual deliberating jury? Common sense is not something that jurors leave at the door. Neither do they leave their personal experiences at the door. That's why jury selection is such an important part of the trial. And remember, there were only 6 jurors on this case. This is Florida. This was not a capital murder case. And so in other felony cases that are not capital murder cases, they only have 6 jurors or jurors, depending on which part you are.
As when a defense or the proponent of this fails to allege facts establishing a prima facie argument for prejudice, they do not get to interview jurors. And it is the state's argument that the defense has not provided prima facie evidence of this. The defense is saying lots and lots of terms and commingling. There's victim of a crime, charged with a crime, custody battle, injunction, and I think it's all getting blurred together. So if you go...
It's not all getting blurred together. It's all a whole bunch of different things that cumulatively, she cannot say, I forgot about that. It was a long time ago.
By exactly what the defense is saying that juror 15 did, the first thing is that she allegedly was intentionally not disclosing that she was a victim of domestic violence. And using the questionnaire where it says, have you or a member of your immediate family been the victim of a crime? Yes or no? And it is checked no. There is no evidence of any intentional deception. There are very, very different definitions of the word victim. Is it a victim in an injunction? Is it a victim in a crime where someone is arrested? How about if you're a victim and someone is not arrested? How about if you're a victim and the police?
Well, we know you didn't think Ashley Benefield was a victim, so we know that you do have a completely different definition of victim. But I think that most people, or most reasonable people, a reasonable juror reading that questionnaire would know exactly what it meant.
Come out and they don't even file charges.
But they
So
did.
that's why it is incumbent upon the attorneys to ask these questions, is to clarify, because not every person answers these questions appropriately because they don't understand.
So you're supposed to, when you've got a panel of, 1,500 jurors, you're supposed to go through each question with each juror and ask, did you lie on this question? Did you lie on this question? Are you sure about this? That's a ridiculous argument. You have to rely on what they put on their questionnaires. There's no time for that.
What exactly legally is meant by these? Additionally, how many times have we gotten questionnaires that have absolutely nothing checked on them? Would that mean that they're lying as well?
No, then you
That's why I
inquire.
believe you cannot rely solely on a questionnaire. You have to delve into it. And the record itself, the transcript that you have, shows that the defense did not delve into this appropriately. Because even when he saw paddles raised, he did not go to those people that raised their paddles. So if he had exercised his own due diligence, perhaps could have found out this information and found out why Juror 15 maybe misunderstood or mischecked this box. But to insinuate that this person was lying on purpose is quite frankly offensive. And I do not believe that we can attribute that to her just based on a written questionnaire when the attorneys did not follow up appropriately one way or another.
You mean by asking the juror if they lied on any portion of their questionnaire? You find it offensive? I think there's a lot of things performed by you and your sister attorney who a lot of people also found offensive.
Also, the fact that she was a victim of domestic violence, according to the standard for non-disclosure, the defense has to show that it was material to the jury service and that it was prejudicial. So how is the fact that this juror may have been the victim of a domestic violence situation prejudicial to a person who's claiming they were the victim of a domestic violence situation? So quite frankly, it's to the contrary. I would think that a juror that was misrepresenting or that was a victim of domestic violence would be sympathetic to a defendant who said, I was the victim of domestic violence.
Well, you're wrong about that. And I can tell you from my chat and my comments and other comments and other chats, some people who are victims of domestic violence say, oh, I was a victim and I had it way worse than she did. She's faking. So this is a disingenuous argument. Not only that, she wasn't just a victim. I'm not saying just a victim, like a victim, like there's any severity to it. I'm saying she was also a perpetrator and her son was also allegedly a perpetrator. So, wow.
So in that regard, the defense cannot show any prima facie case or showing of prejudice.
Does she
Then
believe what she's
the defense
saying?
in the written motion talks about the son was the defendant in a domestic, and then also now somehow the son's a defendant in a bar fight. I'm a bit flabbergasted as to how this even is relevant that he was in a bar fight. I don't recall anyone being asked if anyone had ever been in a bar fight, but
No, I think the question was, any of your family members ever been involved in a violent crime or felony or DV?
the questionnaire says, have you or a member of your immediate family been charged with a crime? And she did answer yes. So I'm not sure where the son's charges fit into this, unless the defense attorney is trying to say that, have you been involved in domestic violence courts somehow encompasses the son being charged. But if it wasn't Juror 15's charge, then why would she answer that question in the affirmative? So I think it's blurring many, many lines together. But when you break it all down, she made no improper representation about her son. She never said anything improper. And none of the questions that were asked by the attorneys in the questioning pertain to anything like this. So the defense cannot show prejudice in that regard either. Then, Judge, there's the fact that she had these domestic violence injunctions. The defense in their motion says child custody / domestic violence / abuse matters. But there's no evidence in the transcript. If you get the opportunity to read the transcript, the state found several places and the defense talked about them. The state did ask, has anybody had a dispute about child custody? Never once did I state who raised their paddle, and I do not represent that I talked to everyone that raised their paddle. Again, I said, has anyone had a heated custody battle? Same thing. People raised their paddles. I spoke to a few of them, make no representation that I hit them all. Then the defense said, has anybody ever been involved in domestic violence court?
If you didn't, then you're not a very good selector of juries. Then you suck at voir dire. So would you rather admit that, or would you rather just admit that maybe this woman did misrepresent? I don't know.
Courts, and that's when the two people raised their paddles, and then he moved on to a different question. So at least where it comes to that, I don't believe there was any misrepresentation at all, or that the defense can show that there was any misrepresentation. And the defense didn't follow up on any of those questions when he asked, has anybody been involved in domestic violence courts? If you read the transcript, he just moved on to another question. He did not follow up with those two people that raised their paddles.
How do you know two people raised their
as
paddles if it doesn't say that in the transcript? Which is it? Either it says in the transcript that two people raised their paddles because you're saying he didn't follow up with the two people that raised their paddles, or it doesn't say that in the transcript. She's all over the place.
As it applies to juror number 15, the state's argument is that the defense has not made a prima facie case of prejudice, or even in most of these, he hasn't even made a prima facie case that the information was withheld or that the juror was untruthful. Also, Judge, this trial lasted 7 business days. So that's 9 days with a weekend. This jury was picked on a Monday. This information was not written in a motion until well after the verdict. This is information that could have been gleaned from the defense, because clearly they got it from somewhere. They could have gleaned this information while the trial was still going on, while we still had alternate.
When they were neck deep or eyebrows deep in preparing for trial on a daily basis, ma'am? Okay.
Jurors here, while we could have asked juror 15 these questions, but the defense waited until after the verdict did not go in their favor to then put forth all of this information, where we are in the position that we're in now. And I believe the case law is very clear that that is not what this was meant for. It was not meant for you to wait to the point where it's irreparable to bring it up, that it should be brought up as soon as someone has done their due diligence enough to find the information on their own. If the defense was going to research every juror, they could have done it during the 9 days that this case was pending while these jurors were still seated.
During
As
the
to
trial.
what I call the second issue, the potential phone in the jury room. First of all, the comments that are attached to this do not have times on them. It says how long the verdict
That's incorrect.
clock. It may be incorrect, but some of the ones I'm looking at do not have times on them. It just says verdict clock 6, like for instance, I'm looking at exhibit A-5 and it says verdict clock 6:18.
If the court looks at the bottom right-hand corner, next to the white space bar on the bottom, it's a clock. And that's where the time stuff goes.
Okay, I can't read that. So if it's on there, is it here? With the little in red?
Space. It's a different clock.
Okay. I can't.
Everyone take a moment to hit the like button if you wouldn't mind. There's over 2,600 in here, and there's only 790 likes. We need to up the ratio. Thank you so much.
But the thing is, you can play these messages at any time.
Did you hear what she just said? You can play these messages at any time. Listen.
Okay, I can't see it. But the thing is, you can play these messages at any time. Anyway, Judge, I do believe that there is some discrepancy about exactly when these comments were coming in, but it is also the state's argument that this is an anonymous source. And we know from the law and how we deal with anonymous sources, they are given the very least amount of credibility. They are not to be believed solely on their own. So we should not give this anonymous source any more deference than we would give any other anonymous source in the legal system. One of the things that is internally inconsistent is that this person is apparently saying his sister is on the jury. And his sister has a flip phone, his sister's giving information. But the comment that says, this is what she just texted me, and then he gives like a colon, per sources, 5-1 guilty. Why would a juror say per sources? A juror would just say, we're saying 5-1. They would not say per sources. That indicates to me that whoever this Hoodie person is, if they are getting the information, is getting it from someone other than a juror, not someone that's on the jury, because why would someone on the jury say it like that?
I mean, we can't see her face during this argument, sadly, but apparently she kept a straight face while she made that argument. Right? Because not everybody that chats anonymously has a super high IQ. I know all of you do, but there are some people out there on the internet that are not, necessarily meaning what they type. Per sources, as if that's, what his sister texted him. Yeah, believe it.
Additionally, the court gave instructions to the jury all throughout the trial, all throughout every break that we ever took. You inquired to them after they came back from every break. Have you gotten any information from anyone? Have you heard about the case? Whatever those specific questions were. And the jury indicated negative each time. The jury never any time during when they were deliberating or any time thereafter said anything to the court that they had information that someone was acting inappropriately or someone had a phone or something like that. They never said anything to you, even though for days and days and days, they knew you were asking this question every single time.
Thank you, Elf.
Also, Judge, even if you do take that this person somehow had a flip phone in the jury room, there is no indication that there's anything other than outgoing texts. Even if there is, which I don't think there was, but even if there is, these are outgoing messages. There is absolutely no evidence or even indication that there was anything incoming that would have tainted this jury.
Does it matter? That's another stupid argument. Let's just call it what it is. It's a stupid argument. If that juror is passing along information to someone outside the jury room about what's going on in the jury room, that is prima facie improper juror conduct, ma'am. It doesn't matter if they're getting text messages back. Wow. And
I would like to read from, it's my motion,
please do.
and it's quoting the Mailer case, Mailer, that I cited in my motion. In order to constitute juror misconduct sufficient to allow post-trial jury inquiry, the objective act must have been committed by a juror which compromised the integrity of the fact-finding process. And then there are examples listed in this case. And some of the examples are: a juror was approached by a party, his agent or attorneys, witnesses or others conversed about the facts and merits of the case in the presence of the jurors. Number 3, the verdict was determined by aggregation and average or by lot, game, or chance, or was other improper manner. Number 4, a jury went to the scene and reported its observations to the rest of the jurors. Number 5, a juror had a personal knowledge of the case and conveyed this knowledge to the jury. Those types of things are listed in the case as being objective acts which compromise the integrity of the verdict. Some anonymous post that we have absolutely no evidence of where it came from, it is more likely than not that this person got the information from some of the press people running around, or maybe court personnel that might have known something was going to happen. There's no indication that this was from inside the jury room. There's no indication that it was anything other than somebody posting on social media trying to get attention. And for us to...
Okay, but if you're going to accuse court personnel of giving information, that too, my sister counselor, is also improper, because look at what's happening with Murdoch and Clerk Becky Hill. The highest court in South Carolina is going to hear that argument for a new trial. And quite frankly, I think he's going to get one. Because shouldn't the number one thing that we're concerned about here is that every defendant is entitled to a fair trial? I happen to think Alec Murdoch is guilty as hell. But if that did happen with Becky Hill, he deserves a new trial. Same thing here.
Inconvenience these 6 jurors in this manner, in this contentious case, in this way, it's quite frankly not appropriate. And this defense has not produced the minimum prima facie evidence in order to get an interview of the jurors. So we would ask you to deny the request.
Thank you. To make a big argument. I don't mind if one of you wants to take the first part of a closing or argument and the other takes the second part, but I don't disagree. It's one or the other. Mr. Taylor, if you want to stand up and you want to address the court for your rebuttal, I'm happy to hear it. If it's going to be Mr. I'm sorry, again.
No, it's okay.
Pinnell.
Refer to Mr. Pinnell, you are.
Yeah, approach the case law.
Yes, or hand it to the deputy. Sure.
Your Honor, I don't want to waste time on platitudes, but everybody in this courtroom knows that the jury system is based on their jurors being honest and forthcoming and giving correct answers, whether they're intentionally correct or incorrect. It doesn't really matter whether they're intentional or not. It just matters whether they're accurate. The state alleges that the motion should have been filed sooner. The rule says it has to be filed within 10 days of the verdict. It's clearly filed.
Hold on. They just whispered something about perjury. So listen real close. I'm going to rewind it to you for you, and you can hear them whispering something about perjury.
Their jurors being honest and forthcoming and giving correct answers, whether they're intentionally correct or incorrect. It doesn't really matter whether they're intentional or not. It just matters whether they're accurate. The state alleges that the motion should have been filed sooner. The rule says it has to be filed within 10 days of the verdict. It's clearly filed within 10 days of the verdict. The idea that Mr. Taylor was supposed to research the jurors while he was busy defending his client, I don't think is a fair assertion. He had plenty to do representing his client in a murder case. The state raises a lot of good questions about what we don't know. And what I would suggest is they've actually proved the point. We don't know a lot of information, and that gives us a reason to interview the jurors. As Mr. Taylor said, the rule does not, although juror interviews are disfavored, the rule has a pretty low bar. It says a party who has reason to believe that the verdict may subject to legal challenge. And it says the motion shall state the name of any juror to be interviewed and the reasons the party has to believe the verdict may be the subject of challenge. And upon a finding that the verdict, quote, may be subject to challenge, not definitely, not 80%, may be subject to challenge, a juror interview shall be ordered.
Shall
Respectfully to the
be.
court, as an officer of the court, I don't think this is a close call. I think there's significant evidence that juror 15 either intentionally or unintentionally did not provide a full disclosure to the questionnaire and to the voir dire questions. What we haven't heard from the state is any allegation that they recall or saw juror 15 raise her paddle and Mr. Taylor not question her. I'm assuming as officers of the court, had they seen that, they would have told you that today. Mr. Taylor's sworn motion says, based on his recall and his notes, that he does not believe juror 15 ever raised her paddle, and that's the evidence that she didn't give a full disclosure. And we're here today to determine whether we get an interview, not whether we get a new trial. And so I do think the state is blending those two together as well. We're not at the point where the court is in a position to decide whether we're entitled to a new trial. We're at the point where the court is in a position to determine whether we're entitled to a juror interview. And I think, again, the evidence that's been presented easily meets that standard. I point the court to the Uther case, and it's Huether versus Barani. This is a 5th DCA case from August 20th of this year. And on page 2, if you're using the bottom right-hand corner, there's a statement that initially we note that Florida law has long recognized that post-verdict juror interviews are strongly disfavored and should be rare. But then they say on page 3.
You're talking printed page 3.
Correct.
Okay.
But then in the second full paragraph in the left column on page 3, it says further, even though Florida law rightly makes post-verdict juror interviews rare, where adequate proof suggests that a juror has acted improperly and contrary to lawful instructions of the trial court, an interview of the offending juror is appropriate.
There you go.
Then in the indented quote on page 3 in the right-hand column, it says it is the duty of the juror to make full and truthful answers to such questions as are asked him. A juror who falsely misrepresents his interest or situation or conceals a material fact relevant to the controversy is guilty of misconduct, and such misconduct is prejudicial to the party, for it impairs his right to challenge.
That's right.
Lawyers representing clients in litigation are entitled to ask and retrieve truthful and complete responses to the relevant questions which they pose to prospective jurors. They are entitled to evaluate this information in determining whether to seek to excuse prospective jurors on peremptory challenge or for cause. So that's what happened in this case. At least preliminarily, the defense has made a showing that juror 15 did not disclose her involvement in domestic violence courts. She was involved both as a petitioner and a respondent. She made an allegation that she was the victim of domestic violence. I understand the state's argument that there's different definitions of victim, and I think that's why we get to ask her questions about it in a juror interview. But this case, this Huether case, is a case where the judge denied or granted juror interviews based on a failure to disclose information, and the opposing party sought to file a cert petition to preclude those interviews, and the 5th DCA said the interviews were appropriate. And
Thanks, Mo.
And in explaining their decision at the bottom of page 3, it says it appears quite possible that JL concealed material information from the court and counsel. So they just say it was possible. Based on the allegations of the party in that case, it was possible, and they found that was enough to justify a jury interview. And then they cite favorably in footnote 6, this is on page 4, before a party to a lawsuit should be denied the benefit of a favorable verdict and forced to endure the time and expense based of a new trial based on juror misconduct, the trial court should at a minimum interview the juror with the attorneys present and then make a finding of whether the contact was intentional and whether any party was prejudiced. So they
Remember, they did it in the Maya Kowalski trial. They called back juror number 1, questioned him about whether he was talking to his wife about the case. It was a big deal. That too was in Florida. Jules, our court watcher, was also present during the Maya Kowalski trial. That was a civil case that resulted in something like a $260 million verdict against the defendant, Johns Hopkins All Children's Hospital. And they didn't want to pay. So they dragged juror 1 back in and they asked him all kinds of questions. And eventually the verdict was upheld, but they did it. And that was also Florida. That's my point.
were saying that before we move on to an appeal or a new trial, we need to be careful and interview the juror when there's prima facie evidence of the failure to disclose relevant information. Certainly based on the allegations and the facts of this case, whether an individual was the victim of a crime, the victim of domestic violence, the perpetrator of domestic violence, would be relevant to whether the defense would seek to excuse her for cause or based on a peremptory. Mr. Taylor has stated under oath and today that had he been provided this information, he would have excused Juror 15. The Hillsborough case, 4th DCA, 2013, under head note 3, it says a juror's non-disclosure of information need not be intentional to constitute concealment in context of a motion for new trial premised on that disclosure. So the state spent a while talking about maybe the juror didn't understand, and that's fine. And maybe the juror didn't understand, but if the information's incorrect, it's incorrect, and it's a basis for new trial. And that's another case where the DCA said that there was reasonable grounds existed for a juror interview. It's our position with regard to Juror 15, the wealth of evidence that the defense has presented easily meets the burden of proof under 3.575, and that the court should grant an interview where she is asked to confirm whether she was the petitioner in those particular petitions, whether she was a respondent in those particular cases, and whether she was a victim of a crime. And that would then conclusively establish for the court whether the information she gave was complete and accurate.
So those are the questions you believe would be asked at the hearing. Were you the petitioner? Have you ever been the petitioner of a domestic violence injunction? Have you ever been the respondent of a domestic violence injunction? Have you ever been the victim of a crime, a domestic violence crime? Is that it?
Those are the first three I could think of. I think there could be a couple more, but that would be the general context of the question.
That's what I guess I'm asking is, how deep does this go? Is it then digging down into the specifics that here's a police report and it says that this happened and this happened?
No, I agree with you. I don't think that would be necessary. I think those first three questions, without thinking it through, I could probably think of one or two more questions, but I think the court's concern is consistent with the case law that it's not supposed to go that deep. All we need to do is establish that it was not accurate at the time the statement was given, or when she failed to raise her paddle, or when she answered the questionnaire. So I agree with the court that it would have to go into more details. It would be limited to that general subject matter, and then we'd be able to make argument whether that was prejudicial.
All right, thank you, sir.
As it relates to the cell phone, it's clearly against the rules for a juror to bring a cell phone into deliberations. We don't know today whether that happened for sure, but I suggest that we have strong circumstantial evidence, and I know the state stands up all the time and tells you that strong circumstantial evidence is as good as direct evidence, that there was a cell phone in the jury room, or at least a reasonable basis to question that under the rule. The YouTube user, that Hoodie guy, said there's a jury, my sister snuck a phone into the room. So the idea that there's no evidence is not true. And then the timing lines up just too accurately for it to be a coincidence. The state is speculating that they may have heard it from a reporter, or they may have heard it from someone else. Maybe that's true, but that's why we get to ask the jurors the questions about it. And I'd cite two cases: the Needleman case, where a juror did outside research and discussed it in the jury room regarding the definition of bribery and the penalty for bribery. And then the Tappanese case, TAPNES 4th DCA, there a smartphone was taken into a jury room, and it says juror misconduct gives to a rebuttable presumption of prejudice. So just the phone being in the room is misconduct. Then we get to argue whether there's prejudice. Again, the timing involved and the sworn allegations made by Mr. Taylor and the attachments establish that there's a reasonable possibility that there's a cell phone in the jury room, and then thus a reasonable possibility that there were not only outgoing messages, but incoming messages that may have been shared with other members of the jury. And the problem with that is that's when we have juror misconduct, when there's outside information is used by the jurors in reaching a verdict. And so we think juror interviews of each juror in the case should be granted, and also on a limited basis. So the first question to each juror would be, did you bring a cell phone into the deliberations? Did you see anybody else with a cell phone? Did you see anybody else leave the room and go in the bathroom and hear them talking on a cell phone? And if any of those answers are yes, then short follow-up, was any information shared with you from the information that was communicated on the cell phone? We don't get to ask, did they rely on it? we don't get to ask, for their cell phone number. We don't get to, inspect their cell phone. We get to find out whether they saw a cell phone, they brought a cell phone into the room, or whether they saw anybody else, and whether that cell phone was used or the information from the cell phone was used during the deliberations. I think it's limited to that, and that's consistent with the case law. It has to be limited. But then we get to decide if that bears any fruit and there was a cell phone in there, then we get to argue whether there was prejudice.
Yeah, then we can get to the next steps.
Yeah.
I know you just came on, so you may have to ask Mr. Taylor the answer to this. Do you know what efforts, if any, have been undertaken to this point to identify that hoodie guy? Again, if you need a minute, I know you just came on.
I do know, but what I know is that they contacted the television station to try to get copies of the texts and emails online. I know the television station was a little bit unresponsive. Beyond that, I don't know what efforts have been made.
All right. Do you know?
That's accurate. No, we were shut down pretty decisively by the television station.
Yeah, Law and Crime is like, we're not getting involved in this. I don't know if they even moderate their chat, but we're like, we're not getting involved in this. We're not giving you any information.
All right.
I don't have anything further. That for those reasons, we believe juror interviews on the first issue, juror 15 should be interviewed on the limited basis I discussed, and on the second issue, each juror should be interviewed on the limited basis I discussed.
All right. Thank you both very much. I'm going to just give you a ruling from the bench because both sides laid it out, I think, very well in your motions, the objection, the case law that was provided. And I will say, even though I had not received yet or reviewed the transcript of the jury selection, I just happened to be there the whole time and have a very firm remembrance of what happened. With that said, at this point, the only issue that is before me is whether to grant the interviews or not. I don't make findings of prejudice. I don't make findings of credibility. I'm not in any way interpreting the posts that appeared in Defense Exhibit A to the motion to interview jurors. I don't express any opinion or thoughts or make any findings regarding the answers given by Juror 15 during voir dire, the answers provided on the jury questionnaire. No findings. The only issue before me is whether to grant those interviews or not, and then, if so, to decide the process that we're going to follow during those interviews. And having reviewed the law, not only the law that was obviously provided by the parties, but reviewing the rules and the case law that is applicable to interview jurors after a trial, it is extraordinary. There's no doubt that this is an extreme step. But at this point, there is sufficient evidence in front of me to grant the request for the interviews.
It's granted. He just granted it.
Issue then becomes the process to follow to make that happen. Again, I think the issues of prejudice and whether anyone would have or would not have exercised a peremptory strike are for another day.
They're coming back. He's calling the jurors back to ask them questions.
So the issues
about
I think we
both
need to
issues.
discuss are several, and I'm going to lay those out, and then I'm happy to hear briefly, and I say briefly because we were scheduled from 1:30 to 2:30, and there's some folks here that are waiting for their hearings. So I prepared to hear briefly on the following issues. Should this be in an open courtroom or in camera? As referenced by Judge Overton in one of the footnotes, which I had, and I appreciate you having that because there's two ways to do it. There's some case law you'll see out there where the court allows the parties to ask questions. And you'll see, of course, in Judge Overton where he approved a process where the court asked questions. My thinking would be if I am going to ask the questions, I'd certainly, you all could tender questions to me and I could decide whether to ask them or not and just see if it's error or not. And then how to bring the jurors that have been released by the court back before the court for interviews. Do they need to be subpoenaed, or is an order to appear sufficient? And an issue that came up today And I will say that I think the cell phone issue, just so you have the benefit of my thoughts, the cell phone issue was certainly, factually speaking, I think more clear in my mind and towards granting the request for the interview. But as I heard the argument and considered everything today, I think the defense has made, I don't want to say a prima facie showing, but I'll use that word. I'll adopt the word you all used. A prima facie showing that you should be allowed to ask some questions and clarify from Juror 15. I do not at all disagree with the framework suggested by counsel, Mr. Pinnell, regarding those questions that I think are relevant and can be asked. And then it'd be up to the defense to argue how that would be prejudicial, and if it is prejudicial, and whatever other issues you need to argue. But what I had not necessarily thought about until it was brought up today is the issue that the jury questionnaires, this is not something we often think about when we're picking juries, are essentially, while not under oath, there is certainly a written, it reads very much similar to the written declaration in lieu of notary in 92, chapter 92, 585. Don't quote me on that. I think it's 585, but it's somewhere around there. The written declaration in lieu of notary. And it does make me think that I should at least offer counsel to Juror 15 and at least give her the option of that. So let's start with it. It's your motion. So I'm going to.
Oh, there you go. He's calling all the jurors back in. He's going to advise juror number 15 that she might need an attorney because this was signed under penalties of perjury, I believe, this questionnaire or something as such, sort of like that. And there could be serious ramifications.
To start with you, defense. And again, when I say briefly, in camera or in the courtroom. And let me just say before we get into too far into this, I see this as a different issue than excluding a witness or a person from a courtroom. I think this is a different matter. So that's why I'm deciding whether in camera or open courtroom. Mr. Taylor.
My instinct and street sense tells me that we will probably get a more candid response if it is in camera rather than the pressure of
I agree. All right. So they will be in camera where I'll let you know specifically whether we do it here and it's electronic or we do it in a jury room or one of the meeting rooms. I'll decide that because also when we bring in the 6 jurors, because my intention would have all of 6 at the same time, but I'm going to put them in separate jury rooms to await the questioning, obviously, just in case you were wondering.
In case you're confused, in camera means outside the view of the public. It will not be a public hearing. And he will bring the jurors in all on the same day at the same time, but call them in one at a time to question them.
Court or attorney questions?
Me again.
Yes, sir.
As much as I would like to question them myself, once again, I think perhaps the most candid circumstances would be most conducive to the court questioning, with the proviso that the parties get to submit potential questions to Your Honor, and with the further consideration that based upon what we might hear, that the court would give us an opportunity for a follow-up.
Go ahead.
I would ask the court to do the questions, but I don't believe that there should be any follow-up.
What was the last part?
I don't believe there should be any follow-up
Oh,
questions.
I don't need follow-up by us. I mean follow-up by the
Right.
court.
So if you think about the scenario in trials where jury questions are allowed and the process we go through, that's what I'm envisioning. As I've said before, I have no problem taking good ideas from other areas of law and plagiarizing and using them. And I think that process, so my intention would be, if you all want to send forward some questions, that's absolutely fine. And those will be what I will work from. And as we go, depending on the information we receive, I may then send that juror out. You guys can pose additional questions to me and go that way. So that may take a little bit longer, but I think that'll be the most effective way to get all the information that both sides are trying to get. All right, so it'll be court questions. The next is how to summon them. I'll just say, I think an order to appear is sufficient. However, I wanted to give you the opportunity to make any arguments in case there was a position or some case law that I'm not familiar with that says once I discharge the juror, my efforts to issue an order to appear is a nullity.
I would suggest a phone call from the court's JA would do it, and I think that that would be the least intrusive and the simplest, and in the event that one of the jurors rejects that, then I think we can address subsequent measures to the court. But I would guess a phone call from the JA requesting that they attend the proceeding would be sufficient.
I would defer to the court, Judge.
All right. I appreciate that. You would be shocked the number of people that don't respond.
Yeah.
But with that said,
Phone
I think
call's
I'm going
not
to do
good.
an order for each juror to appear, each of the 6 jurors to appear on the date and time. So I'm going to have Kelly reach out and coordinate with the both of you to find a day and a time. There's 6 jurors. I would love to say 10 minutes each will be done exactly an hour, but I don't think that's realistic. So I'll probably ask her to block off 2 hours with you all. And this really, you don't have a dog in this fight. I think this is really more of a concern for the court. Does anybody want to be heard on the issue of Juror 15 and her order to appear, having the offer of court-appointed counsel?
So I can only address this from my perspective as criminal defense attorney. If Ms. Walcott were, well, let's use a hypothetical. If somebody similarly situated as Ms. Walcott were to come to my office and I made arrangements to represent them, I would advise them to invoke their Fifth Amendment right to remain silent for 2 bases. One, potential perjury, and we can say, Suzanne can stand up and say, look, we have no intent of charging a former juror. She may feel differently, or her office may feel differently in the event this results in a new trial. And secondly, I would advise my client to invoke the Fifth Amendment, Judge White, based on the fact that as a result of her failure to respond properly to the voir dire questions, that she has exposed herself to direct criminal contempt by the court. And the court may very well have the authority to assess costs of that prior trial. So I think you'd be doing the right thing to advise her.
I'm just going to make the offer. Do you want to be heard?
No.
Okay. All right. So I'm going to advise Juror 15 that she is certainly entitled to hire an attorney, or the court will consider appointing an attorney to represent her if she financially qualifies. And then she can certainly make those arrangements through my office. We can put her in touch with who she needs to fill out that paperwork. All right. So with that said, I guess keep your phones on or your emails open. We'll be scheduling a 2-hour block. Send proposed questions if you want.
Can I just ask a question about the questions for Juror 15? Are there some parameters that, I mean, what exact questions is the court looking for to accept?
I don't think it would be appropriate for me to give you that a preliminary ruling. I'm just saying submit what questions you want. I'll ask the questions I think are appropriate. There were some suggestions earlier by Mr. Pinnell that I think I spoke favorably of, but I'm not making any preliminary ruling. Submit what you want asked.
And I guess my question is, ultimately, can we have discussion if we do have an objection to a question? Or is it the court's discretion?
I think it's ultimately my discretion.
Okay.
I think this falls squarely on my shoulders. I just want to give you all as much input and opportunity to be heard as I possibly can.
Okay.
All right. Thank you all very much.
Thank you.
I'll be issuing an order, but it'll be a very short written order.
Okay, yeah, I don't know if the judge wanted, if you wanted to at least consider scheduling. We've got.
Okay, well, so here's what what happened was the judge has sent an order to each of the jurors to appear, and they are going to have to appear Friday. I think it's a Friday, October 4th at 9 a.m. for a 2-hour hearing. And our friend Jules is in the courtroom that day, and she's here with us now. And so I'm going to bring her on so that she can tell us what else happened. Hi, Jules.
Morning, Melanie. How are you?
I'm great. How are you?
I'm hanging in there.
Good. So what everyone does not know is that Juror 15 was actually in the courtroom during this entire hearing.
She was. And first off, let me make a correction that Court TV incorrectly stated live on air the day of the hearing. They incorrectly stated that Juror 15 is also the juror in question for the flip phone. That is not correct.
There's no evidence of
Okay.
that.
That is not correct. That never came up. That is not what is in dispute here. What's in dispute here is if a juror did in fact have a flip phone with them in the jury room, which one had it?
Right.
Nowhere at any time was juror 15 implicated in that. So I wanted to get that out there because I do have to say juror 15 was very upset.
Well, here's the thing. Are you telling us that Court TV was spreading misinformation?
Correct. And I went on
Shocking.
Twitter. I went on Twitter, and it was Ashley Wilcock, Judge
Well,
Ashley
Judge,
Wilcock.
uh-huh.
I'm not saying it was deliberate. She may have misspoke. She may have misunderstood. However, I did correct Judge Ashley Wilcock on Twitter of that because it's bad enough what juror 15 allegedly has done.
Mhm.
And then to have that thrown on top of her was, I just felt that was wrong.
Yes, agreed. Okay, so tell us what happened. So before this hearing, juror 15 made an appearance and came up and talked to the judge, right?
Correct. I got there really early, and when I went down the hall to sit outside of the courtroom waiting for them to unlock the door, she was sitting there, and I immediately recognized her. And no, I did not approach her. I was like, yeah, stay away from this.
That's right. So you went to the trial mostly every day. So
Yes.
you recognized her as being the
I
juror
did.
or a juror.
Yes, she sat in the first row, and she was 2 seats from the gallery. She was like the second person in from the gallery in the first row,
Mhm.
which was one of them, I have to say, took very little notes during the trial. So I was quite surprised to see that. So when they unlocked the courtroom door and we entered, she sat directly across from me. I sat where I normally sit. And truth be told, I thought that's where Mr. Taylor was going to be sitting. And so I sat on that side of the courtroom. She sat directly opposite me. So when everybody came in, the prosecution team was on my side of the courtroom, and Taylor was on her side. And the first thing that happened was the judge called, yes, I know her name, but I'm not going to use it.
Yeah.
Called juror, said that the first motion he was going to hear was the motion that was submitted by juror number 15. And I almost fell out of my chair because she filed a motion. So she
Mhm.
got up to the podium. She was very soft-spoken. Don't everybody jump on me, but I actually did feel bad for her.
That's okay. We have empathy, Jules. We have
Yeah,
empathy for
I
people.
did feel bad for her. And what her motion was in regards to, she requested Judge White to seal the criminal records on her.
Mhm.
And he asked her, this is the problem when you go pro se, okay? Because she was acting as pro se. When you submit, and I've done this in family court for myself through my divorce, but I had help. So I knew in motions, you need to cite statutes, okay?
Mhm.
And he asked her, well, what statute are you applying this for? It was like, listen, I can't just arbitrarily, willy-nilly steal your records. And
Right.
of course, she couldn't cite anything because what she said was, it's humiliating and embarrassing that my personal information is out there. So on that note, I did feel for her. But ultimately, the bottom line, and Mr. Taylor, Judge White asked Mr. Taylor and asked the prosecution, did they have anything that they wanted to add before he made his ruling. Neither of them had anything to add. And Judge White denied her motion and said that offered her a second time to come back to resubmit a motion stating under, what rules, what statutes for him to seal her records. And so that was over, and she left the podium and she went back. I thought she was going to leave, but
Mhm.
she didn't. She sat down in the courtroom across from me. And then Mr. Taylor got up. Judge White asked Mr. Taylor, to proceed. But before Mr. Taylor proceeded on his motions, he brought to Judge White's attention that she was still sitting in the courtroom. And because she was the subject of his motions for, juror misconduct and wanting to have the jurors brought in, he asked Judge White to have her escorted out of the courtroom. And Judge White said, well, what is your basis on that? And Mr. Taylor said, potentially she's going to have to get on the stand and testify. And I
Mhm.
want her in here while I'm making my argument. Well, Judge White came back and said, no, the courtroom is open to the public. That means all public. And because no ruling has been made yet on your motions, I can't ask her to leave.
Mhm.
I thought for sure after that, she would have gotten up and left, but she did not. She stayed throughout the entire proceedings. So Mr. Taylor, as you saw, Mr. Taylor talked quite lengthily at first in regards to juror 15. And I don't know if you could notice that I kept looking over at her because she wasn't outwardly crying, but she did have tears coming down her face. I did feel bad for her on one hand, but on the other hand, it was, you were the victim of DV. You were a perpetrator of DV,
Allegedly.
allegedly,
But
but
there's records. Yeah.
I read court records.
Yes, I know.
I read them. I'm sorry. Once I knew, then I went in and was like, oh my, there's history here. So in any case, so I did feel bad for her. I thought Mr. Taylor did really well. I felt that he did better during this hearing. And I know you're watching, Mr. Taylor.
I think he's great. He's a fierce advocate.
He did better. I think he did better during this hearing. He had some moments. Come on, Melanie. Let's be honest. There were some moments
Freezing
during
on
the
me.
trial where the ball was dropped. But in any case, I think he did really well, and he brought in the appellate attorney with him. So I thought that was a really smart move. And
Mhm.
because I was directly behind the prosecutors, wow. They were not liking it at all. Now, the blonde, I could only see the back of her head. But
Ms. O'Donnell. Yes, Miss
Yes.
O'Donnell.
But the
Mhm.
brunette, the one with the white streak, she sat this way, sideways the entire time. So everything she said, every pussy look she had on her face, I saw it all. And she wasn't having it. She was with the finger like this
Oh,
to her
really?
co-counsel there. And like she just wasn't having it. And I think a lot of what you saw with the blonde one getting up,
Mhm.
I think a lot of it had to do with being provoked from her co-counsel, because she really was pretty much laid back, and it was like, um, you know, that's the way that was. I was very upset at one point when she got up there and she brought up about every day, you asked the jury, did they have any outside influence, this and then that. Well, and she said, we never had an issue. We didn't have a problem. So on my notepad, I start writing a note, right? I'm like, no. We did have a problem. We had a big problem. We had an incident at the deli.
That's
And
right.
so I was writing this down and I was trying to pass it to Mr. Taylor's paralegal, but he was across the aisle and I wasn't going to get up in the middle of all of that. But I was like, oh my God, she just bold-faced lied.
Yeah.
Anyway,
Or she
you
just
saw what,
forgot.
yeah. So what the end result was. I was pleasantly surprised that the judge ruled in favor of the defense. Because of the past history, and there were some moments where there was a little testiness between Mr. Taylor and Judge White, and so not a whole lot, not the way it was during trial, but there was a few moments, and I thought, yeah, he's not gonna do this. So I was pleasantly surprised, as well as the prosecution was unpleasantly surprised.
I wish
that
we
he
could have seen their
ruled.
faces after his
It was
ruling.
priceless. So that's how that went. So after court, I do have a message for sweet Melanie, attorney Melanie Little. I did have a conversation with Mr. Taylor and his team after court. He asked me to extend his thanks personally to attorney Melanie Little and her chat. He felt that you conducted your stream, you gave Ashley dignity. He felt that you were fair at all times. You gave constructive criticism. He appreciated it. He also said that he appreciated the support that your chat had shown during your live stream. So I told him that I would make sure. I did not put this out on Twitter. I kept this because I wanted to make sure that you were told personally. And so that is Mr. Taylor's message to you, Melanie. I asked how Ashley was doing. Don't you dare cry.
I know. It's just like, you don't ever think that people are watching you. And it's like, I get accused all the time of like being paid by defense, like I was being paid by the defense on Karen Reed. It's like, I get up here and I talk about things that outrage me. And I try and be a voice for people who don't have one. And if I wanted to get all the clicks and the likes and the views, I would have been on the side of, Ashley Benefield is horrible, guilty, throw her away. And, like same thing on Carly Gregg. And so sometimes you have to talk about the unpopular things. And that warms my heart that maybe the people in this community are making a difference. So thank you.
Yeah.
And thanks to Mr. Taylor. And,
So I asked him how Ashley was doing. And, obviously he gave me the standard answer. She's holding up as best she can under these circumstances. I asked him if Ashley is aware of the public support that she has been receiving, and he did indicate, he answered affirmative. Yes, she is very much aware. I also said to him, boy, Mr. Taylor, I didn't think you were going to get a win today. And he said, neither did I.
Wow. That's always such a happy day when you walk in thinking you're going to lose, and then you're pleasantly surprised that maybe there is a justice system that we can start to believe in again.
Yeah. So so the team was quite happy that they walked away with a win. And I did say to him, I said, and this is true. I don't know if people have asked you, Melanie, but people have reached out to me because they knew I was there. Is there anything that they can do to help
Yes.
where Ashley is concerned? And so I asked him, and he said, yes. And I was like, he said, you could write a letter to the judge. And I was like, really? I said, do you want it to go through your office? And he said, no, send it directly to the judge, which I have that information here. And in particular, it would be helpful if the letters are from victims current of DV and survivors past DV victims. So, of both. So if you're someone who hasn't publicly or confided in family or whatever, and you're going through something like this, it may be therapeutic if you wrote a letter to Judge White and say, hey, this is what I've gone through. And I'm just saying, that's if you believe that Ashley was a victim of domestic,
Mhm.
and if you believe that she has been unjustly found guilty. I'm not, I want to make sure that everyone knows I am not telling people what to do. If you find it in your heart or you have belief in Ashley Benefield, then I will provide you, with the address on where to send your communication. But if you don't want to do it, you don't have to do it.
A lot of people have asked how they could help, and that is that's a way. If her attorney okayed it and said maybe that would help. And I just want everyone out there to know that if you do write a letter to the judge, it probably will become public record. It will become part of the court file. It'll be marked. It'll be right in there. So, you're not going to maintain any sort of confidentiality. So just so that you know that it very well may become part of the court record if you
That is
choose to
correct.
do that.
That is correct. So get your pens ready, folks, because if you choose to write a letter, and I did see someone in the chat asking if it's exclusive to Florida. No, anyone can write a letter from anywhere. So it would be the Manatee County Courthouse at 1115 Manatee Avenue West, Bradenton, Florida, 34205. And on the bottom of the envelope, please put attention Judge White, 9th floor criminal.
And also it's White is WHYTE.
Correct. So if anyone wants to do that, there you have it. Her sentencing, again, depending on what happens on the 4th, is going to be October 22nd. I believe it's 1:30 in the afternoon. Also too, obviously, you guys know Ashley was, waived her appearance in that hearing last Monday. There were 3 people in the courtroom there to represent her, one of which I recognize that was in court every single day during the hearing. The other 2, I recall them being there a few times, but not on a regular basis. And that was it. Though it was those 3 and Juror 15 and me.
Wow. I'm surprised that she didn't come to this hearing because it's a day to get out of jail. I have the hearing. I have the sentencing on here for Let me just see. October. I have it down for October 22nd and 8:30, but let me just.
Oh,
I
it's
could be wrong.
8:30?
No, I
Okay.
could be wrong. I'm looking at the court file now. Yeah, I have it on for 8:30.
Okay.
So
So,
October 22nd, 8:30, in front of Judge White at the Manatee County Judicial Center, and then I
and
have
I'm sorry. Go ahead.
the hearing for the jurors to come in. I have as October 4th at 9 a.m. And I do see that juror number 15 has filed a notice of appearance, or her attorney has
Right.
filed a notice of appearance. She's being represented by a man named Brett McIntosh and Kevin Griffith. So I'm not
And
sure if
they're
that's appointed or
I don't know. I do know that Judge White was very open to the fact of let's go ahead and appoint her one. So
right.
um
Because
I'm
that's fair. Why should she have to pay for an attorney? Like that's a very nice offer. They didn't offer juror number 1 that
no, they
in
they
Maya.
said, well, you might want to think about having one, but juror number 1 had nothing to hide. So he's
Mhm.
like, I don't need a lawyer. And he also was offered to do an in-camera interview, and he declined. He was like, I don't have anything to hide. I don't care, you know, it's already out there who I am. So
Right.
he didn't care. Um uh, I am the law and crime thing.
Mhm.
I just remembered. The whole timestamp thing. She was trying to say that there were no timestamps. Well, there really was, okay? And the witness that Mr. Taylor had on Zoom waiting to zoom in if the
Mhm.
judge allowed was, how do I word this? Okay, Mr. Hoodie, the Hoodie guy, yeah, he's an anonymous she is an anonymous person, okay, who was in that chat. However, this was a chat person that was in the chat in real time as this was happening, and did the screenshots in real time as it was happening,
Mhm.
and provided it to Mr. Taylor.
Wow. Yeah,
And
and if they needed that witness, she was there, or he or she was there and ready to testify, but he didn't allow it, but he still granted the motion. So there you go.
yeah. Um so yeah, that was the other big thing that I wanted to let you know on. So yeah.
That's fantastic. Let me see if anybody else has any questions for you. Latina, they did a story on Ashley on, what do you mean for 40? You mean 2020? With that annoying lawyer. Yeah, Stephanie Murphy was on that. She was interviewed for that. The female and cousin Tommy, turn my stomach, how evil they are. Yeah, thank you, Latina. And also she says, Stephanie Murphy, the lawyer, also said on 2020 they should take Ashley's daughter from the grandma since she had her outside protesting. The audacity of that lawyer. That was the thing that really, about that 2020 episode that I watched, that I just found I just found her demeanor to be just, I, I I don't even know how to describe it, Jules. How did she know like so much information without even really playing the clips? It's hard to even talk about it. We can maybe do that on another show. Um, but Stephanie Murphy just seemed so personally invested.
Very much. And I don't know if I asked you this before or not. I know I raised this question with someone. So if I did, just
Sure,
remind
we
me.
can always address it again.
The day that she was testifying, she was out in the hall in between, because she was on the stand, then she was off, and then blah, blah, but in between, on a break, I saw her and Detective Gillum together, sitting together. I could not hear what their conversation was, but they were right next to each other with their heads and, and talking back and forth. And I thought that was, in my opinion, highly inappropriate. However, I also thought that they were both witnesses. Are they supposed to be, granted, I don't know what they were talking about, but were they
Mhm.
supposed to be sitting together like that? And I wanted your thoughts on that,
Well,
Melanie.
I don't know at what point of the trial it was, if they had both already testified, if they both had been released from subpoenas, if it was before he was going to testify. So yeah, it depends, but they're
They
not
weren't
supposed to
dismissed yet.
be.
They weren't released yet.
It's not a good idea. It's not, yeah, violation of sequestration.
That's what I was thinking.
Could be. Well, we know what happened in the deli.
Yeah.
2020 plus 48. I think the 48 hours one aired a long time ago, though, right? Or is that a different network? I don't know. Do you know? Because I remember a lot of
I
the
don't
stuff in the
know.
2020 episode we had already seen, because that those were interviews that happened way before the trial. Same kind of thing that they did with Karen Reed. So I think
Yeah,
that they did
and
the
then
48 hours and then they cobbled together pieces of that interview into the longer 2020 interview. Thanks, Latina. What were you going to
yeah,
say, Jules?
I didn't like that. I did watch that show, and I was again, Stephanie Murphy was so involved even in that, documentary.
Mm-hmm.
I don't know what her motivation is. I mean, I speculated, but I'm not going to say publicly what I speculated. But she certainly has gone over, like,
Above and
she,
beyond the call of
yeah.
duty as far as like an attorney-client relationship. I felt that she just, I don't know. She was too invested in it. I don't know if she wanted to be on TV. I don't know. I mean, look, it's great to, I guess, be on 2020. Maybe you get clients out of it, but some of the
Well,
things that she was saying that she was vehemently denying that Doug ever did, like, how would she know really what happened? Because none of us know. We weren't there. Thanks,
no.
Mama She, for the 10. She says, I wasn't prepared for the evil stepsister this morning. Need more coffee. We all need more coffee. 48
Yeah.
hours was after the trial. It was a different interview, Latina? All right, I'm going to go look for it. Thanks. Thanks
Well,
for the
yeah,
tea.
because you could see it earlier on in the show, she looked different. Her hair was darker. Da, da, da,
Mhm.
da, da. Later on, she had the blonde hair. So it looks like they took pieces from prior to the trial and then added that into post trial. But I felt that it was very one sided.
They
They
usually are, right?
Yeah, but I thought, I don't know. I just thought it was there was not anyone speaking up for Ashley in that show. You know,
Right.
there
Right. Thank you,
wasn't.
Latina. 48 hours. We're talking about Ashley being after the Ashley being filmed. But did they interview Ashley after the trial?
No,
That's what I'm curious about. So,
no.
there was there were some clips in the 2020 where you could see, she had a couple of those gray hairs that people were swearing that she did on purpose, that she put there on purpose. So you could tell that that was like either immediately right before, I think it was right before the trial started. I don't think the trial was ongoing, but it was closer in time. Thanks, Latina.
The stress will do that to you.
Yes, we all know that.
Yeah, stress will do that to
Oh,
you.
all right. I'm going to wrap this because I'm doing a show at 1:00 with Carly Gregg's attorney. So thank you so much for coming on. Do you have any final thoughts that you would like to
No, just,
say?
if you all, feel that you want to go ahead and write a letter on Ashley's behalf, I would suggest you do it fairly soon because her sentencing is on the 22nd of October. But love you guys. Thank you as always, Melanie, for
You.
having me. I'll probably see a lot of you at some point because I don't know if you're going to be doing Sarah Boone, but I will be there for that trial.
When is that trial starting?
October 8th.
It's really going to start
Jury
on October
selection.
8th? Wow.
Well,
I
there
thought
is
that
a
was like
hearing.
far away.
No, there is a hearing Friday, a status hearing on Friday. I don't think Judge Kranick, though, is going to delay it. I think he's going to stick with October 7th jury selection. He's
Wow.
hoping by the 8th, the jury will be seated, and boom, we start. So I will be in Orlando for that. And,
Wow.
so thank you guys for your support as always. Melanie, I hope Mr. Taylor made your day.
Oh my gosh, you have no idea. You sit out here screaming into a closet and you never know if anybody's listening or if it's making a difference with, trying to just help people be a little more understanding and empathetic. And tell everyone where they can find you on Twitter or TikTok or whatever it is.
Oh gosh. I think TikTok is, by the way, that's the other thing. I did do a standout. I led a standout here in Florida, Labor Day weekend for Karen Reed. That
Oh,
went
you
over really
did?
well. Yeah, well, there was about 20 of us, but the majority of the people, I have to tell you, are transplants from Massachusetts.
Interesting. That's
One,
so cool.
a Boston retired police officer. So I got a lot of scoop with him on what's happening
Wow.
up there. So yeah, in any case, so yeah, it's Notorious Jules or blind_gossip 1423 on TikTok. And it's again Notorious Jules on Twitter. And I don't know what the actual thing is, but you'll find me.
Of course,
If
I
not,
always
somebody
find
knows.
you. So how far
Yeah.
is Duval County from you? Is that far?
Duval?
Yeah, because
Um,
Shanna Gardner is going to be coming up. There was a hearing this morning, but it was nothing. It was scheduling. That's not going to be coming up for a year, though.
yeah, that's Jacksonville. So yeah,
That's
that's
far.
that's
Far.
about a 5-hour drive, between 5 and 6 hours away. But Orlando is 3.5 for me, but I booked a room
Oh
and
wow. Okay.
yeah, so I'll be out there. And Frankie, my little dog, will be with my son in Tampa. And on the
Frankie.
weekends, I'll go back, to my son. So
Carrie was at that Karen Reed standout. That's awesome. Thank you, Carrie. All right, Jules, I
All
got to go get ready, but I will
right,
let
take
you
care.
go while I
Love
say
you
goodbye to
guys.
everyone. Thank you so much. We love you so much. Thank you so much for coming and sharing such excellent news. Wow. Happy birthday. Happy birthday, Sarah Lee Johnson. So there you go, my friends. There you go. Ashley, I just want to say Ashley Benefield. Ashley Benefield's attorneys, Ashley Benefield was granted the motion for juror interviews in her case with regard to potential juror misconduct and juror number 15 potentially lying on her jury questionnaire about having been a victim and perpetrator of DV and involved in a custody battle and involved in other cases of DV involving her son, and her son maybe had been accused of a felony or arrested for a felony immediately before the jury was picked. This juror was in the courtroom during the hearing we just watched. We did not know that. Well, I knew that, but you guys didn't. And the judge had called her up before this hearing, and she had made a motion to have her records sealed in the court file, the DV records and other records that were published in the court file. And the judge, because she didn't have any authority for it or statute or case law, he declined it. She is now represented by counsel. They will be holding these juror interviews on October 4th. It will not be televised. We will find out what happens for you, and we'll stay on top of it. And then, depending on what happens with those juror interviews, Ashley Benefield is scheduled to be sentenced on October 22nd. Thank you all so much for joining me today. Thank you for my amazing, amazing moderators. VK Saw, that says I deserve accolades. Thank you. Thank you. I'm just saddened to see that in so many places, there's just such a lack of just basic empathy and understanding. And I get called all kinds of horrible things. So thank you guys so much for, being here and keeping it classy and being nice. And to the moderators who make this a great place, thank you so much. And to my cupcakes who want to be a member of my channel, I love you so much. And I want to thank all of you viewers, replay viewers. Please smash the like button, share the stream out so that we can get some more awareness here. And also, as soon as I end the stream, you will be teleported to the 1:00 stream that I will be having with Bridget Todd, Carly Gregg's attorney, to answer all of your questions. She's not afraid of your questions, so bring them. I will see you very soon in about 1 hour from now. So remember, my friends, just be cool, be kind, be classy. It's not hard. I promise you, it is so not hard. See you in an hour. Night. Night. Good afternoon. See you soon.